Ladies and gentlemen, welcome to the main event.
Today, we're diving into the complexities of the WARN Act, especially how it affects companies during big changes like layoffs or closures.
Absolutely. It's a topic that's become even more relevant with recent economic shifts. The WARN Act isn't just a legal checkbox. It directly impacts employees and employers.
Right, and many people don't realize how strict those requirements are. For instance, companies with 100 or more employees have to provide 60 days notice before certain layoffs.
That's true, but it's not always straightforward. Do you think most HR teams are fully aware of these nuances, or do companies sometimes get caught off guard?
I think many are surprised by the details. For instance, not all terminations trigger WARN. There are exceptions, like if layoffs are temporary or if the closure was caused by unforeseeable business circumstances.
Speaking of exceptions, unforeseeable business circumstances is a phrase that pops up a lot, but defining what's truly unforeseeable isn't always clear.
Exactly. Take the pandemic, for example. Some companies argued their closures were unforeseeable, but regulators still expected proper notice. It gets murky quickly.
That brings up enforcement. Penalties for non-compliance can be steep, back pay, and benefits for affected employees. It's a risk companies can't afford to ignore.
And it's not just penalties. Reputation takes a hit. Imagine a brand that handles layoffs poorly. Employees talk, and it can scare away future hires.
Totally. I read about a company that tried to skirt the rules by staggering layoffs, hoping to stay under the reporting threshold. Regulators caught on. It's not a loophole you can easily exploit.
That's a good point. The rolling layoffs approach often fails because the law looks at the aggregate impact within a 90-day period.
What do you think about the role of unions in this process? Do they help employees get better notice or protection?
Sometimes they do, but the WARN Act applies regardless of union status. Unions might negotiate extra provisions, but the baseline legal requirement stands for everyone.
It makes me wonder, do employees often know their rights under WARN, or is this something that catches them by surprise?
Honestly, many are unaware until it happens. Employers should communicate clearly, but sometimes the information comes too late.
Communication is key, but so is documentation. Companies need to keep records of notices sent and timing, or they risk legal challenges.
On the flip side, have you seen examples where clear WARN compliance actually helped a company's reputation during tough times?
Absolutely. There was a tech firm that gave 90 days notice, held Q&A sessions, and helped with job placement. People praised their transparency, even amid layoffs.
That's the kind of story you wish was more common. Do you think regulatory agencies could do more to educate both employers and employees about these rules?
Maybe. Some states have their own mini-WARN laws too, which adds complexity. More education could help reduce confusion and mistakes.
Speaking of states, California's WARN law is stricter than the federal version. It covers smaller companies and different thresholds.
Yeah, compliance isn't one size fits all. Multi-state employers have to juggle federal and state requirements, which can be a headache.
I can imagine legal teams trying to keep track of deadlines on spreadsheets, like some kind of compliance bingo game.
That's one way to add a little fun to a stressful process. But jokes aside, missing even one notice can lead to lawsuits.
Technology helps, though. There are platforms now that automate notifications and track compliance, reducing human error.
Still, human judgment is needed. Deciding what counts as a mass layoff or a plant closing isn't always clear-cut.
For sure. The law has specific definitions based on numbers and percentages. A layoff of 50 employees may or may not qualify, depending on the total workforce.
And if you're a distributed company, figuring out which location counts as a site of employment can be tricky.
That's why legal counsel is so important. It's not just about checking boxes, it's about understanding the nuances.
Sometimes companies learn the hard way. There was a retailer that shut down a store overnight and ended up paying months of back wages.
It's a cautionary tale. Planning ahead and consulting experts can save a lot of trouble.
And let's not forget, the human side matters. Layoffs are tough, but treating people fairly can make a difference long term.
So true. Even when business realities force downsizing, empathy and transparency help preserve trust.
In the end, the WARN Act is about balancing business needs with human impact. Do you think the law strikes the right balance?
That's a tough question. It's not perfect, but it does set a standard for fairness. Maybe future reforms will address some of the gray areas.
And until then, companies need to prioritize compliance and clear communication. It's better to over-prepare than under-inform.
Absolutely. For listeners facing layoffs or closures, knowing your rights under WARN can make a big difference.
And for employers, getting proactive with compliance isn't just smart, it's the right thing to do.
Thanks for tuning in. Whether you're an employer or employee, stay informed and advocate for transparency in your workplace.
And remember, a little legal knowledge goes a long way. Until next time.
A special thank you to MarketUS.com for furnishing us this information. You can reach them at MarketUS.com or call them at 954-636-3232. Before we go, this deep dive was created by the MarketUS.com team. Let us know your thoughts in the comments below. It's right below the subscribe link.